Good morning, Mr. Brissette, Mr. Ellison. The next case we are hearing is Township of Fraser versus Haney. This is a 20-minute argument per side. Mr. Brissette, you may attempt to reserve some of that, but we ask you to try and keep track of it. I will interrupt you after a couple of minutes for questions, and you may proceed.
Thank you, Your Honor. I'd like to start by giving you a fact scenario. The fact scenario is as follows. A township resident owns an 80-acre parcel, and it's wooded, and it's nearby a bunch of residences. And the residents have been complaining about mosquitoes for years, and the township and the county come by and spray regularly for mosquitoes. But still the mosquitoes persist. And no one can figure out why. And one of the local residents decides to go for a walk, and in fact, he goes on the 80-acre parcel. And he discovers a massive mound of used tires. And he calls the township and says, there's a massive mound of used tires on that parcel next to us. Can you do something? Because that might be where the mosquitoes are breeding. So the township calls the owner of the property and they say, can we meet you on your property? Because there might be some concerns that we need to address. So the property owner says, sure. And they meet on the property and go for a walk, and they come upon this mound of used tires. And the township says, gosh, it's a huge mound of used tires. That might be where the mosquitoes are breeding. How long has that been there? Oh, I started collecting used tires 7-8 years ago, said the property owner. And the township representative said, can we come on your property and spray? And the property owner said, oh no, those mosquitoes are food for birds, and I like birds. And the township official asked, well, how do you get those tires? Well, the local tire stores bring me used tires, and I charge them $5 a tire, and they dump their tires. And that's been going on 7 or 8 years? Yep, said the property owner. The township official looked around and said, what are all those barrels doing over there? Well, I collect the barrels. Well, what's in the barrels? I don't know. Well, who brings the barrels here? Well, local chemical company. Well, don't they tell you what's in the barrels? No, they don't. And I don't ask. Well, it looks like some of them are leaking. The property owner said, yeah, they might be. Township official looks around a little bit more and says, well, how long have those barrels been there? Oh, about as long as the tires, I'd say 7 or 8 years. And the township official looks around some more and sees some vent pipes sticking out of the ground.
Mr. Brissette, I think I get where you're going with this hypothetical. It's a good one. Let me interrupt you though, just to see what questions my colleagues have. Okay, I'll start with Justice Bernstein.
Well, I don't have any questions yet, but if you could come back to me towards the end.
Absolutely, happy to do that. Justice Clement.
No questions right now, thank you.
Justice Cavanagh.
None for me.
Justice Zahra.
I was waiting to find out if there were some hogs in the barrel. No questions.
I could try to inject that.
Okay.
I wasn't planning to.
Thank you. No questions at this time.
I skipped you, Justice Welch. I apologize.
No problem. No questions.
Justice Bernstein, I'm back at you, but we can come back to you again. I'll let Mr. Brissette continue with his argument if that works.
Yeah, if you could.
Absolutely. Mr. Brissette, you may continue.
Well, I'll continue with my fact scenario.
Oh my gosh, I'm so sorry. I skipped Justice Viviano too. I'm losing it. I'm only seeing the people in my top row. Justice Viviano, I apologize. Do you have questions at this point?
No problem. No questions. Thanks.
It's like my bottom row disappeared. Mr. Brissette, go ahead. And if anybody has questions, I'm just going to tell them to interrupt you and ask them at this point, if that's okay with you.
That's fine. So he asked what the vent pipes were sticking out of the ground. Well, those are vent pipes for my underground storage tanks. Well, what's in the underground storage tanks? Asked the township official. The property owner said, I don't really know. I allow people to come on here with their tanker trucks and dump whatever they want to into my underground storage tanks. I don't ask what it is, and they don't tell me. And I charge them $500 when they bring a tanker truck in and do some dumping. How long have you been doing that? Well, about the same time as the tires, about 7 or 8 years. So the township officials left, feeling very frustrated that if indeed all those activities had been going on for 7 or 8 years, under the Court of Appeals opinion in Township of Fraser versus Haney, they were handcuffed. So continuing the story, a year later, a severe case of West Nile virus broke out in that area. And 2 years later, the people were getting very sick. And finally, it was discovered their water wells were contaminated. Now I'll give you another fact scenario.
Let me interrupt because I'm getting a little bit lost on this one. But the Court of Appeals made a lot of discussion or discussed the abolition of the continuing wrongs doctrine. Is that at all pertinent? Why does that matter?
The continuing wrongs, I don't think really applies to what we have here. On the date the complaint was filed in this case, there was a violation of the zoning ordinance. This zoning ordinance, as probably all zoning ordinances in the state of Michigan, say that there is a new violation every day the zoning ordinance is being violated. And that language was approved in an appellate decision and is probably as uniform as any language would get among various zoning ordinances in the state. So on the day the complaint was filed in this case, there was agricultural activity on commercially zoned property. And the day before it was filed, there was agricultural activity on commercially zoned property. So I don't think it really applies. If you look back at some of the decisions, like the Maryland Froling case, where you had a golf course erect a berm, and then later it was alleged to be a nuisance and there was flooding. There was one activity years past, which was the erection of the berm. However, in this case, there is continuing illegal activity every single day. And if you want to equate it to other types of illegal activity, you could, but for each day there is illegal activity, you have a new wrong, a new case. So I don't think it really applies.
Thank you.
Mr. Brissette, can I ask a question? So assuming doesn't it sort of rise and fall or start and finish with the ordinance and this sort of perhaps intellectual question of whether or not this is an action in personam versus in rem, that also isn't necessary to actually resolve this case. Would you agree with that? Or do you think we need to dive into that?
It's an interesting analysis, whether it's in personam or in rem. The argument would be any zoning is really an in rem activity because you're not zoning people, you're zoning land. And the appellate cases, including City of Detroit versus Haas, would seem to indicate that what we have here is an in rem proceeding, not an in personam proceeding. And to that extent, the statute barring personal actions, which is the statute we're addressing here, wouldn't apply to in rem actions. However, going beyond that, is that analysis necessary? I don't believe so, although I think it's instructive to look at it. Because if you have a new wrong on the day the complaint is filed, and the wrong is relating to land use that's covered by the township's zoning ordinance, I think that's enough.
Okay, thank you.
Mr. Brissette, you may continue, or you may reserve some time for rebuttal.
I'll continue. The second fact situation I wanted to explore with you is two people bought some residential property 20 years ago and decided to conduct a contracting business from that residentially zoned property. And they continued for 20 consecutive years operating a construction company from that property. And over the 20 years, the area built up with houses, also on residentially owned property. And after 20 years, there were complaints about dust and truck noise and truck traffic and the activity that was going on with this contracting business. And the township sent a letter saying, hey, stop, you're residentially zoned. They didn't, and the township sued to abate the nuisance because it was a nuisance per se, just as our case here. And the circuit court allowed the township to pursue its abatement action. And the Court of Appeals affirmed. Now that fact situation is the same fact situation as the case of Township of Lyon versus Petty, which I cited extensively in my Court of Appeals brief and also mentioned it in my argument. But I think the Court of Appeals opinion was very goal-oriented, and anything that interfered with the goal of enforcing the statute of limitations or saying it could be used as a defense was simply going to be ignored. So you won't find any reference to that case, Township of Lyon versus Petty, in the Court of Appeals decision in this case, although it's directly on point. In that case, there was 20 years that went by with this construction activity. And reading the opinion of the court, it appeared the township knew about it and didn't react until there was a complaint by a local resident. In that case, quoted from Jerome Township versus Melchi, which had, I believe, a 9-year gap between the Melchis starting a beekeeping activity and Jerome Township initiating proceedings in circuit court to abate the nuisance, or what they thought was a nuisance. So
I have a question. I mean, and I'm just trying to follow the arguments here. And I guess my question is, going back to Justice Cavanagh, I mean, so we're not going to address the issue of in personam. I just want to make sure I understand kind of the real essence and crux of your argument. Is there any limitation in terms of the time that is established between the potential violation of a statute and the ability for the township to act? Or, I mean, is there any limitations whatsoever, or should there be? Or, I'm just trying to get to the crux of it.
I don't believe under existing law there is any limitation.
So would your argument, I just want to understand your argument. So if I'm a landowner, now I understand in the analogies that you're using, is there, so would your contention be that there's no limitation in terms of if a person's been using their property for a certain period of time and ultimately there's been no activity taken by the township? Is that your contention is that as long as there's a violation or a perceived violation, the township should be able to act?
That's correct. What you're talking about is an invalid non-conforming use. In other words, a non-conforming use that began after the adoption of a zoning ordinance versus a non-conforming use that existed prior to the enactment of the zoning ordinance. In other words, those uses that are grandfathered in.
So ultimately, if a landowner does that and has done that for a considerable period of time, the issue is that as long as it's a non-conformance use, there is no statute of limitations and the township can take action whenever it deems it to be necessary.
That's correct. Now, I can't say that the landowner would be without some equitable defenses being estoppel and latches, although the appellate decisions that dealt with those defenses would seem to indicate it's quite a heavy burden for the landowner to succeed, because in the case of Township of Lyon versus...
But I just want to make sure I confirm it, but your argument would be there's no period of time necessary for the township to act.
That's correct.
Okay. Thank you, counsel.
You're welcome.
Counsel, if you want to reserve a couple of minutes, you may do that at this point.
I'll reserve a couple of minutes then.
Okay, thank you so much. Mr. Ellison, if I hide my tire mosquito chemicals, if I just can hide them for 6 years, am I all set going forward?
I have to unmute myself. Philip Ellison on behalf, I have to do a housekeeping matter before we start talking about mosquitoes. Today, Your Honor, I'm here on behalf of Eppley, Harvey Haney. Mrs. Haney, which is Harvey Haney's mother, co-owner of the property, has passed away. Under the court rule, she's required to be dismissed, and I actually can't even represent her based on her passage. So I just want that record to be clear for today. Second of all, I would say before getting to the mosquitoes, all the arguments presented by Mr. Brissette today were never raised in the trial court. None of these issues are preserved. Almost all the issues the only argument he made in the trial court level is that if in fact a statute of limitations was available, a court of appeals case would have dealt with this at some time. He's raised none of these issues. So for example, when he just argued that every day is a new violation, I never had a chance to respond to that because he never raised that in the trial court. If he had raised that argument, one of the arguments I had intended on raising in that respect would have been that the statute of limitations preempts the entire field of being able to avoid the statute of limitations. This case is poorly structured to resolve these issues here today because they haven't been sussed out, and it comes to you on an interlocutory appeal. So almost all the arguments presented in this case were done by amicus counsel, not by township counsel. And I think it's wholly inappropriate that these arguments are being sussed out because, for example, the brief of Professor Fisher has got factual errors in them because it comes to the court on an interlocutory basis. So, and of course, I didn't get a chance to respond to any of the amicus because they filed them all after I filed my Eppley brief. So getting those objections and concerns out of the way, which I think are serious issues to resolving what is a very major concern here, I would argue that the legislature has provided us the answer. It's the three statutes that I've cited in our case. It's 5813, 5815, and 5827. What we're seeing in this case is the attempt by amicus as well as by Mr. Brissette to change the statute of limitations affirmative defense that was challenged here into a laches defense. Laches was not argued in the mid-discovery motion for summary disposition. Statute of limitations provides that all personal actions, and Mr. Brissette in the trial court admitted this is an in personam action. As he said in the appendix 57 and B and 58B. You can't sue a legal description. This is a suit against an individual that all actions have to be commenced with after the claim accrues. And of course, the claim accrues when at the time the wrong upon which the claim is based was done, regardless of when the result or when the damage results. Now, the argument we've seen from amicus and somewhat hinted at in Mr. Brissette here this morning is that somehow because this is in an equity-based case, that this should somehow be outside the statute of limitations. None of the amicus, and Mr. Brissette included, did not reference 5815. 5815 provides the answer for this case. The period of limitations apply equally to all actions, whether equitable or legal relief is sought. The statute of limitations is 6 years. If the township is sitting on its hands, it would be inappropriate. Now, getting back to the mosquitoes, let's get to the mosquitoes here, Justice McCormack. That is, in every case, we're going to have a circumstance where it sounds like a terrible set of circumstances. Probably pretty soon you're going to see me again before you on these tax equity cases where the government has taken people's property for over the last 20 years. Many people are not going to get a refund because the statute of limitations precludes and protects the government from causes of action against it. What's good for the goose is good for the gander, which is somewhat the argument I made below. Much as the government, much as the private citizen is subject to the statute of limitations, so should the government be in that respect. So bottom line is, as to the mosquitoes, the township needs to do a better job at regulating the local enforcement of its local ordinances. If it's much like an individual who's been harmed by a police officer has to bring their 8th Amendment claim in due time, so should the township be responsible to bring an action based on mosquitoes, based on toxic waste, based on any other aspect. One last point I would like to make before we go to questions, because I can see you're about to jump on me with the questions here, would be I would point this court to Trentadue. In Trentadue, this court applied 5827 to the claims involving dioxins in the Tibbetawasi River. The dioxins were in the river the day before the suit was filed. The dioxins were in the river the day after the suit was filed. And yet 5827 applied in those circumstances to preclude the cause of action of pollution, the very same parallel Mr. Brissette brings, and this court prevented those causes of action from going forward. Unless this court is prepared to overturn Trentadue, Henry, and the continuing, and basically GARB, which is the abolishment of the continuing wrongs doctrine as a common law doctrine, 5815 provides the remedy that this court must apply. And I'm happy to open up to questions.
Thank you. Justice Bernstein, I'll start with you, but we can also come back to you, whatever you prefer.
Yeah, please. And I just want to ask a question, just from a practical perspective, counsel. And first off, I'm just trying to understand this, practically. Is your overall contention that if the township isn't aware of the violation within that period of time, the violation can continue indefinitely?
So it would be the same argument that would have been had in I always say it wrong, but Lathathan, the case in the last time the township or this court spoke about the individual. He was the officer from the Detroit Police Department who did not know he had a cause of action. And this court, while sympathetic to the fact that Lathathan was barred by the statute of limitations, still applied that statute of limitations, even though he didn't know that he in fact had a cause of action that he could have sought. And he sought an exception, much like Mr. Brissette is seeking an exception to 5815. And it's unfortunate because, one of the things as lawyers, we always want to seek justice for individuals, obviously. But at some point, there has to be a reasonable cutoff, because my client, who's been operating a pig farm on the basis of what the supervisor told him originally, that it was okay to do that, has been operating and has built his farm for over 10 years, now even longer now. I mean, we're up to almost 15, 16 years now at this point, has expended extensive amounts of time and money on the basis of what he believed to be the case. And if the township is sitting on its hands, waiting until it's the worst possible time financially for a farmer to be able to have to undo his incomplete operation, that's simply unfair. And the point is, the legislature, when balancing these competing interests of timely bringing a claim versus the harm that's caused by not bringing a timely claim. The legislature is the policy body that should make that determination, and it has done so with currently under Chapter 58 of the Rejudicature Act.
Counsel, thank you.
Thank you.
Justice Clement,
No questions.
Justice Cavanagh.
Was your client in violation of the ordinance at the time that the claim was filed?
So the short answer is yes. He had
Okay, so how do you address then the existence of the ordinance that says, you know, that it's a new offense or harm occurs each day?
Well, first of all, I would argue, as I did at the top of this, that argument was not preserved by Mr. Brissette at the trial court level.
I understand that, and let's assume, I mean, I think that that's a valid point. We are all concerned with process and procedure, but we have a Court of Appeals published opinion.
Correct.
That we have an obligation to make sure is in fact correct. And so you have an ordinance that says every day that the violation occurs is a new action. Your client was violating on the day that the complaint was filed, and apparently at least every day for the past 6 years within what you contend is the statute of limitations. Why does the ordinance not apply to permit the action that the township was taking?
2 points. One is, I don't believe the township has the authority to create a daily violation. Essentially, they have codified the continuing wrongs doctrine, which again, my position would be is that had that issue been raised at the trial court level, we would have argued that there's an implied preemption that's there, that the township does not have that ability. The wrong here is not the harm. And that's what, I mean, and that sounds kind of basic when you think about it, but that's what the difference that Trentadue and Henry that explains, particularly Trentadue explains, is that there's a separation of the wrong that occurs versus when the harm is being felt. In the case here is that the harm was the existence or creation of the piggery. It wasn't the existence of the fact that there was smells coming from the piggery. And so one thing, if we could draw, I know Mr. Brissette this morning has drawn on examples. Let me draw on one myself. Pretend you loan me $500 and I say, I'll pay you back right away. Is each day thereafter I don't pay you back a new violation of the contract, so that when 6 years or 7 years later you sue me and you say, well, I'm not trying to enforce when you didn't pay me back originally.
What if the contract said it was? Is it enforceable? If the contract said you agreed to pay me back tomorrow, and every day that you don't is a new violation, which is essentially what the ordinance says, why are we not enforcing that?
Because I think the difference here is that if the purpose of such an ordinance is simply to extend the statute of limitations indefinitely. And my argument would be is that the Michigan legislature has preempted the ability to indefinitely extend a cause of action out based on local ordinances, or in this case, a contract in that respect. I mean, I haven't considered the fact about a contractual provision as opposed to an action at law that way, but and I mean, that's something I'd have to consider in further detail. But you know, the basic part of this is that it's a violation. The violation is when there's the violation, when you didn't pay back, right? And that's why this court, of course, got rid of the continuing wrongs doctrine, is to say you can't continue this daisy chain to indefinitely keep these causes of action alive forever, because it runs contrary to the language contained in the statute. Because again, 5813 provides it has to be commenced within 6 years after the claim accrues, not afterwards, unless a different period is stated in the statutes. So if the legislature wants to create a special cause of action for the township or for the contract person, in your example, they can do so. The remedy here is not this court trying to, massage the statute to fight the mosquitoes or to fight the parade of horribles. The remedy here is for the township to go to the legislature and ask for a special exception to be added to section 1521. And that would be what I would respond with.
Okay, thank you.
Justice Welch.
Yeah, thank you, Mr. Ellison. So I'm grappling with, obviously the dioxin case that you cited, where, a chemical is put in the water, and obviously that has negative consequences for people. in this case, isn't the comparable conduct the presence of the pigs? Pouring the chemical or getting the chemical in the water and the presence of pigs. I would agree with you that it would be comparable if, say, there was, pig waste left on the land that then contaminated the land. I'm just having a hard time kind of uniting those two cases.
Well, I think it goes back to the pleadings here. If you actually look at the complaint alleges it's the existence of the piggery. It's not the existence of the pig, and it's not the existence of for example, pig feces, for example. Because the complaint, otherwise, I can't draw a distinction between this court's decision Trentadue and the circumstances here. The chemicals now, and again, I'm from that region up here, from where dioxins were in the water. They're not in the water. They're in the water. They're in the lake riverbed. They're there. They're there today. In fact, they were there the day before that lawsuit was filed. They're there the day after the lawsuit's filed. And this court applied 5827 and said it's when the harm or when the wrong occurred. The wrong that was alleged in the complaint here was that the existence of the piggery, when you opened the piggery in this respect. And otherwise, what this court is doing is it's substituting harm for wrong. And those are two distinct concepts that the legislature has separated out in the statute itself. Now, again, if you don't like what the statute says as a township, and especially as apparently as well connected as the township is, pulling all the amicus in that they have, would be is to petition the legislature for an amendment to the statute so that it does have the authority to regulate those aspects beyond, or for example, and I know that, let me just take a side step here is that, the township's essential argument and the amicus's argument is that it's just a parade of horribles if we have a statute of limitations. We have statute of limitations that apply to crimes, people that commit rapes or murders or not so much certain types of murders or other aspects. We require that the government bring those claims on a timely basis. Now, the same arguments that the township could have about mosquitoes is it, could the fact that the person committed a crime try to be concealed so they don't get charged? The same issues apply there. But the legislature has balanced those two concerns and said there's a time frame for criminal actions, there's a time frame for civil actions, and in this case, the civil action is when the wrong occurred. Now, if the township had pled it differently, they may have a different cause of action that exists here, but they didn't. What they pled was the existence of the piggery, and the existence of the piggery came into place undisputed in 2006. And they brought the lawsuit almost 10 years later, which now, of course, is now almost 16 years later in this respect.
Justice Zahra?
I understand that you, Mr. Ellison, would have us conclude that the bulk of this is unpreserved. It's an interlocutory appeal, and we should simply deny. But if we aren't inclined to go there because we have concerns about the Court of Appeals opinion, would you like the opportunity to respond to the arguments raised by the amici?
If this court is inclined to take action beyond saying that these issues were not preserved, which I think is fatal for this particular appeal, I would welcome the opportunity. Of course, I have over 100 pages of briefing to respond to, of course, from 5 or 6 different amicus that have filed in this respect.
Well, you've presented a very articulate argument today. Are there things you feel you haven't had an opportunity to discuss an oral argument? I mean, look, I'm offering you the opportunity to file a brief, and now your response is, I'll file a brief, but I need 100 pages.
Well, I don't mean to say I don't need tit for tat, the 100 pages, but I guess what I would like to point out to the court is that the amicus went well beyond what the township itself in the principle that Justice Viviano in the Bizzio case in his dissent pointed out is the principle of party presentation. It would need to be generous as opposed to 100. But there are issues that need to be addressed, because if you in fact grab onto the amicus's argument, those are all issues that were never raised, and I was never given an opportunity on behalf of my client. And one of the big ones I think there is that this idea of this that the township can legislate that each day is a new violation is in fact been preempted by the legislature under the statute of limitations. And of course, none of that got fleshed out because of course the trial judge ruled that this was an in rem action as opposed to an in personam action. And, essentially what we're arguing today is not anything that was argued about me and Mr. Brissette originally back in the trial court. I guess let me ask you this way. If you're going, I never want to cut off the opportunity to brief, obviously, but I would suggest to this court that the appropriate remedy would be is to remand this case back. If the court has a concern about the fact that the Court of Appeals erred in some way, would be is to vacate the Court of Appeals decision and return the case back for full case development and allow the township to then reappeal. Now, are we essentially hitting the reset button? Yeah, you're giving the township another chance on the arguments that they should have raised below. But that may be, if the court has that level of concern, that may be an alternate path to go forward in this respect.
Thank you.
Justice Viviano.
No questions. Thank you.
You have a little over a minute, Mr. Ellison.
So I guess bottom line, I would leave it as is. It's always tempting for the parade of horribles for, the mosquitoes and the chemical dumps. But I'd also ask this court to consider Mr. Haney. He relied on a township supervisor who told him it was fine to put pigs onto the property. And for the last 16 years, he's invested his blood, sweat, and tears into his small business, with money from investments from his mother, as well as from investment of family money to operate this pig farm in reliance on the fact that they thought he could proceed in this respect. And now the township, after waiting 10 years, sitting on its hands for 10 years, suddenly says, we need to destroy and you need to leave the township in your business operations completely outside of our borders, because there's basically no other place for them to go with the way the land is available for him to purchase. It's unfair. And the reason why it's unfair is that it gives the township the authority at any time to sit on its hands and to veto a business when someone starts to complain. The legislature is the one that balanced these particular conflicting principles and came up with the correct solution. And the court should apply the principle that the legislature came up with. Thank you.
Thank you. Mr. Brissette, you have some rebuttal time.
Thank you. I'd like to address 3 items. Number one, Mr. Ellison said that the piggery was there for 10 years and that's undisputed. That's absolutely false. I attached as Exhibit B to my brief a 2009 letter from the Department of Agriculture, which went on the property and did a survey of every single animal on that property. And not one was a pig or a domestic pig. They noted the presence of some wild boars, which are not domestic pigs. Those were governed by the DNR. And at the time, they were legal to have. Subsequent to that inspection, the DNR decided it wasn't legal to have wild boars, and Mr. Haney had to get rid of it.
I have a question because I want to really understand this. I think this is really important to me, is the concept of equity. If you could address what Brother Counsel has basically said, and I understand you're getting specific with the letter and the exhibit, but I want you to address conceptually the notion of what does a business owner or a person do if they have been told that what they're doing is appropriate, if they've been told that what they're doing is okay. How do we address this? I mean, how do we address this issue? They were told that, according to Brother Counsel, that, they could do this, that they built a business around this, they invested around this, and then all of a sudden they're being told something different. How as a judge should I not be concerned about that?
Well, Judge, let me address the former supervisor's statement that it was okay to have a piggery. That's absolutely false.
Okay.
Don't assume that's true. No former supervisor orally told Mr. Haney he could have a piggery.
No, but I don't want to get into the facts because that's not what our court does. But what I want to understand is conceptually is the notion of, I just want to understand that conceptually this notion that if a person basically is operating for a certain period of time. They've been operating for a lengthy period of time. You know, what duty does the township have to a person to do an inspection in an appropriate time so that people, before a person basically goes and makes financial investments and is basically rendering their business, their home in a certain way? I mean, basically, ultimately, the question is, what assurances does either a homeowner or does a business? I know here we're doing business, but you know, let's focus on that. What assurances does a business owner have that ultimately that the township or the government's not going to come to them at just some certain period of time and basically say, tear it all down?
Well, actually, there are appellate decisions that have decided that where a zoning administrator or a building inspector approved something that should not have been approved, the homeowner suffers the consequences because the activity or the construction should never have been approved. And if you want to relate this to equities, then the appellate decisions that have addressed some zoning cases have looked at the availability of latches and estoppel. And those theories were discussed somewhat in the Township of Lyon versus Petty. And the way they analyzed it is just how much did the property owner do and how much expense did they go to do whatever it was they were doing in reliance on somebody either being tacit in their approval or actually giving approval. And they did analyze that, but in that case, they said that the defendants didn't meet the threshold they needed to meet to present an estoppel or a laches defense.
Okay.
But
Look, I think you've answered it. I think you've answered it, my question. And thank you for coming and thank you.
Thank you, Mr. Brissette. Mr. Brissette, Mr. Ellison, your time is up. Thank you both for your presentations. The case will be submitted.
Thanks, Judge.